Welcome, everyone. We're just going to get started now. I'm Celeste Pagano-Bowles, and this is my colleague, Keith Edmiston. And Keith, you can turn on your mic, but I want to welcome everyone to BarMax today. This webinar is for people who have been unsuccessful in a bar exam. You have some things going for you. You've been through it. You know what to expect. But obviously, you have challenges of various kinds. Today, we want to help you get to where you can assess what went wrong, what you can adjust in your study strategy for next time to bring you to success on your upcoming bar exam. I'm Celeste Pagano-Bowles. As I said, I'm the content director and head of instruction here at BarMax. And with me is my newest instructor. He's new to BarMax. He's not new at teaching the bar. And before that, he spent 7 years as a bar examiner for the state of Tennessee. So you'll be hearing from Keith with his expertise at bar exam essays later on. But if you want to just say hello, Keith.
Hello. Hey, folks. Welcome.
Okay. Welcome. That's all he needed to say right now. You'll hear plenty from Keith later. Thanks. So before we begin, I have a couple of just sort of housekeeping type announcements. I see already that there's some stuff going on in chat, and that is great. If you have comments for each other and put them in chat, and it turns into a side conversation, make sure you're just chatting with that person so it doesn't get super distracting in there. If you want everyone to see it, make sure you've put all panelists, or put everyone. I guess it's everyone. And if you have a question about your specific situation, want to know more about BarMax, want somebody to reach out to you, we have an awesome BarMax rep right here in this session, helping out with answering questions in chat. So that's where to put all your stuff. Now, if after we progress through some of the major content here, it raises more questions for you that you think should be answered in the session, okay, not specific to your situation, but general questions for everybody, go ahead and throw those in the Q&A, because Keith and I will be taking questions and answers at the end of our presentation. And that's it for announcements. I do, want to let you know that before I even get into the core of my content, which I do want to get into, so I won't spend too much time here, but we have been very successful with people who are retaking the bar exam. And if you were overwhelmed by other programs and found that there was too much to do, you want to go read some testimonials on Trustpilot or on the App Store or on our website. You'll see that some people have found this to be a better solution in terms of having streamlined materials and a flexible program that people can work with. This was a very long testimonial, but this person, credits BarMax for her success as well, saying the materials were concise and what she needed. But we'll also talk about some strategies and methods today, because it's not just about the materials, it's about what we do with them. Well, let's start with really what's going on, right? What's going on right now are some feelings, right? This is a feelings chart. I found a very comprehensive feelings chart. Some of them have like 10 things. No, you've had 10 negative emotions in the last few days if you recently found out that you failed. It's incredibly disappointing. You might be disappointed. You might be embarrassed. You might be angry because you feel like this whole process is so frustrating and arbitrary and maybe in some way unfair. You might be really anxious about the prospect of taking it again. And you're probably disappointed and discouraged because you wanted to get on with your life. And why do I mention all this? You're like, duh, I know. I've gone through a whole box of Kleenex already. Let's move on. We will. We're going to spend most of the time moving on. But it's important to acknowledge, because some of you have people in your life who are telling you, buck up, you're a smart cookie, you've got this, and not really letting you feel that this stinks. It's a very, very difficult thing to go through. It is helpful to know that in all of this kind of generalized crumminess, you are not alone. Okay. We mentioned in the little promo materials for this webinar, people like Governor Jerry Brown, longest serving governor in the state of California, was also the state attorney general in between those gubernatorial terms, a bunch of other stuff, mayor of my original hometown of Oakland, California. He did that too. Incredibly accomplished human being and lawyer. And yet he failed the bar exam on his first try. But even more than the famous people you see on the lists, okay, which is all true. There are thousands upon thousands of intelligent and competent lawyers who are practicing law in courtrooms today, or in transactional settings, or in mediation settings today, throughout this country, who took more than one try to fail the bar. I'll be sharing maybe some of their stories along the way too, because, you know, Keith and I have both worked with students who had to retake the bar, but there's usually some kind of adjustment that has to be made in order to succeed on a second try, or third, or in one of my students' cases, seventh, before getting to that goal. But you still have that goal of being a lawyer. You've still put in a tremendous amount of work and schooling to get to this point. You are going to get there, right? It's just figuring out what you need to do. So that's our goal for today, is to refocus, is to figure out why you failed. Okay. We want to see if we can do some diagnostic of some of the things that might have happened. And so that we can make adjustments along the way. And then once you've sort of figured out a strategy, you're going to look at your schedule, you're going to plan your work and work your plan. Someone who helped me with scheduling my very first year of law school, that was her mantra, and I've kept it. Plan your work and work your plan. It's working for me in this job. Because there's always a lot to do, no matter, you know, what our field of responsibility. So let's look at some of the main reasons that people fail the bar. And we are going to spend the most time on one of them, but let's get the other two out of the way first. Suspect number 3 is exam week sabotage. We'll talk about some of these things that may have happened to you, or that you may have made happen to yourself the week of the bar exam, that you can do differently next time. For some people, it's that they didn't study enough, that they were balancing work and family commitments, or otherwise distracted, and thought that, oh, I can put in these hours and it will be enough, but really didn't give it enough focused time. But most often it is suspect number 1 here. People who focused on the wrong things, who put in a lot of work, but did not necessarily have all of that working to their greatest benefit in terms of raking in the points that they needed to pass the bar. Let's get these first two out of the way first. Exam week sabotage. It usually looks like one of these 4 things here. Food, hydration, sleep, or outside factors. You'll notice that 3 of the 4 things on this list are within your control. Okay. And why would I mention, oh my goodness, I did not come here for a nutrition seminar. Okay. You got some of your Halloween candy right next to you on the desk. I know you do. Maybe. But seriously, there's plenty of studies, there's plenty of articles out there that tell you that making sure that you take care of your body is an important part of your exam performance. you have all taken a bar exam. So you know what a brutal test of endurance it is. It is physically has some things in common with a marathon, and that it goes on all day, but no, it goes on all day for 2 days. You have to sustain an incredible amount of focus. I mentioned food. This is one article out of many that talk about healthy foods to eat when you are preparing for a big exam. I think one that people focus on less is it doesn't show. Here we go. Here it is. Okay, my disappearing glass of water. Hydration is really important. Even slight dehydration reduces your ability to focus and concentrate. So you really need to be intentional about taking care of yourself the week before the bar in order to not sabotage yourself. The biggest way people sabotage themselves is by pulling a bunch of late nighters. They realize, oh, I haven't memorized. I have to memorize this entire, pile of outlines, and, or even just the BarMax outlines, which are more condensed. And there's stuff I don't know. So I have to stay up late memorizing it, okay, which is completely counterproductive. One, our memory is consolidated during sleep. So you, if anything, should be sleeping more during the period you're working on memorization. Okay. And, secondly, it is going to kill your ability to focus during the exam. And as we'll talk about when we talk about study strategies, it is not how much you know. You do need to know a lot, but you don't need to know everything to pass the bar. What you need to know is how to apply what you know in the way that the bar examiners are looking for, both in multiple choice questions and in essays. You need to know. You don't get points for knowing a rule. You get points for knowing what rule to apply and how to write the analysis on an essay. Keith's going to help us with this a lot. And you get points for knowing when a rule does or doesn't apply to a particular weird, convoluted fact scenario with a particular weird, convoluted question stem in an MBE question. Okay. These things are difficult, and it's that skill that's being tested. So the background knowledge, you could know everything in the outline and still not pass the bar. Whereas conversely, you could know 85% of the outline and do great if you're applying it well. Okay, so I would say getting to that panic where you start not sleeping for the week or two before the test is another one of the 4 kinds of exam week sabotage. Okay, moving on to the second of the usual suspects is the people who, as I said, something in their life kept them from studying so much or enough. If you have challenges in scheduling, lots and lots of BarMax students study full time. If you use BarMax as your program, the day you buy BarMax, the day you have access to it is the day you have access to it. You don't have to sit there and wait for some arbitrary calendar to tell you when to start studying. Okay, if you purchase BarMax, you can start studying today, or if you already have it, you may have already started studying. And then you can pace out your study schedule over time. I did a webinar on this, and this one is available within BarMax and on our TestMax YouTube page. If you search TestMax Bar Exam, you'll find my previous webinars and some other previous webinars we've done on test-related subjects. But let me see. Whoops. I started getting distracted by chat. See what happens. Okay. And in one of those webinars, I did talk about scheduling. Okay. So it's scheduling your bar exam study. Maybe Katie will put a link in here into the chat. This gives kind of 2 major concepts about how to establish these 3-hour blocks of focused study time when you will do most of your focused study. and what to fill in those blocks. And newsflash, especially for you as retakers, it will not be necessarily listening to lectures, reading outlines, doing flashcards. Those are the less effective uses of your time. Your best hours of study time, your most focused time in your schedule and your week needs to go to doing practice questions. Again, if you decide to work with a tutor next time around, we'll talk about self-diagnosing, whether that is something that you will need to do, or you decide if it's something you want to do. We've had plenty of people who've passed with bar exam or BarMax tutors. You'll see that the top testimonial here is someone who passed as a repeater and full-time employed person. So, but working with a tutor can help you with even that scheduling component, as well as with, understanding the substantive law better. So let's get to our number one things. Either there is not enough real practice, already said it's too much overlap with real MBE and essay questions, or sometimes people practice MBEs and practice MBEs, but they neglect essays. Okay. They don't turn in any practice essays. They say, I used BarMax, but I didn't do any practice essays, or I did one. BarMax comes with 10 free essay reviews, and they're not that expensive to buy more. And we give detailed feedback about your performance on the essay, not just whether you knew the law, but whether you're putting it in your answer in the format that's going to get you the most points. So absolutely use that. And we also talk in BarMax about open book bar exam study. If you did a bunch of MBEs, but you didn't do any of them or many of them open book, that is cheating with the outline open, then you did not get the most out of those MBEs. We want you to do open book bar study, particularly toward the beginning. So if you didn't do that at all, and your score was just a few points short of where you need to be, just doing that will change your understanding enough to get you to where you need to be, probably. Okay. There are some people who have the opposite problem. They practice and practice and practice, but they don't get to that memorization, which is that brute force memorization. In our calendar, we put it at the end of the study cycle that you're really focused 100% on brute force memorization. It's the last 2 or 3 weeks before the bar exam. But when you are reviewing the subjects, the second time through each subject in our calendar, we want you to be creating the memory tools that you will use during that memorization time. Sometimes people, do pretty well because they understand how the rules apply, and maybe they do pretty well on most of the essays, but they haven't really memorized the elements of the rules, so they miss all those tricky MBE questions that rely on knowing the elements to the business records exception of the hearsay rule, or other very picky things. They're hard to hold in your brain for a long time, but we want you to have them in there in those 2 weeks prior to the exam. So usually people who fail for suspect number 3 reason here, it's one of those two. They either didn't do enough practice or they neglected to do the memorization they needed to do at the end. So the next thing I'm going to talk about before I throw it over to Keith is how to read your score report. A lot of states are going to give you 2 numbers. And here there are 256 and 136. They say, here's your score, 256. This is just an example. And here's your MBE score, 136. And you say, what is this? What can I learn from this? Well, New York requires a 266. So we know that this hypothetical student here fell 10 points short. Okay, that is not an insurmountable gap. making some adjustments, the student will be able to pass next time. But, where did they do well? Where did they falter? Well, first of all, they don't put the essay score on here, but we can get to it by some simple subtraction. Okay. So if this student got a 256 overall, half of the points available come from the MBE multiple choice and half come from the writing, MEE essays and MPTs. This is on a UBE uniform bar exam, like New York, Illinois, North Carolina, Missouri, 38 DC, which just came out on Friday, DC and 38 jurisdictions altogether use the uniform bar exam. But if you're in a state that doesn't use the UBE, but uses the MBE, you can still kind of make this same extrapolation. They tell you your overall score, they tell you your MBE score. Well, then you know that on your writing component, or in Florida on your state component, you scored the remainder of your points, which here was 120. So this example here is someone who really needs to work on their writing. Okay, we'll talk about some of the things that may have gone wrong with writing. And people sometimes ask me, should I order my essays? Now, you might be in a state that does not release your essays and will not let you see how you did. Or there's, I think, one state still, I think it's Iowa, where they'll let you go into the office and read them, but they won't give them to you. What's that? Anyway, I think it's worthwhile if you can get to that office, but especially if you're in a state like New York, where it costs, I think, $20, $25 to get your essays, absolutely order your essays. Now, I know that you're thinking, or maybe not even thinking, you're just here. Right? Getting your essays back is absolutely nerve-wracking. You're worried that you're going to feel some of the young people on this list. You're worried you're going to feel embarrassed or ashamed. Okay? Or that, it'll make you scared to think, oh, if this is how I did, how am I going to do next time? So yes, you have those feelings and you're going to overcome those feelings because you know that your goal in ordering your essays is to learn what you can learn, to diagnose your problem. So you're going to be brave, like this kid in the bottom row here. You see this kid brave, and the kid next to that one, focused. You're going to be focused on learning what you can from these essays. And who better to show us what we can learn from reading our past bar exam essays than Keith Edmiston, who's about to turn on his mic and has graded more than 7,500 real bar exam essays in his career as a bar examiner. And we are delighted to have stolen him from the competition. I mean, that he recently joined BarMax as a BarMax instructor, and he works with me on content, and he's terrific all around. And I am pleased and proud to introduce Keith.
Thank you, Celeste.
I'll stop sharing so you can share.
Sure. Okay, so what I'm going to do with you is go through some examples of where people might fail in drafting their essays on the bar exam. And some of these will be sort of glaring examples. Okay.
So go ahead and share your screen so we can see the examples. Yeah. And then I'll get out of here and mind my own business.
I got you. Okay. So let us share this. I'm sorry, folks. It'll just take a second. I promise. Okay, so I'm going to share my screen, and this is a little PowerPoint presentation I put together to, to show you what, might be particularly relevant when you're looking to see what you may have done wrong. Okay, so hopefully you all can see my screen. So a couple of things I want to reiterate to what Celeste said, and that is, you can know all the law that there is to know. You could even know 100% of the law, but that, there's more to it than that. And for example, in the essays, if the only thing that was tested was your knowledge of the law, it'd be an MBE question, right? So there's something else that's important that the bar examiners want to see on an essay exam. And so I'm going to give you a few examples of things that you might have done incorrect. And again, these may be kind of glaring examples, but it gives you an idea of certain things that you might need to work on. So this is called things that might have gone wrong. And at the end, we're going to look at an essay that might be a good answer. Okay, so we're going to start out with the facts, and I'm going to read them to you just because I don't like silence. And that is, a man was driving his truck at a high rate of speed when he struck a woman who was backing her car out of the driveway onto the same road. The woman was significantly injured. A police officer and paramedics arrived just minutes after the accident happened. The woman was unable to speak to the officer due to her injuries, and an eyewitness yelled to the officer just as he arrived. The woman pulling, I'm sorry, you know what? My video is covering my thing. However, an eyewitness yelled to the officer just as he arrived. That woman was pulling out of her driveway when the truck slammed into her. The truck was going so fast it came out of nowhere. The officer thereafter approached the man who was standing beside his truck. The officer took down the man's information, including his proof of vehicle insurance, which is sort of the norm, right, when you have an accident. The woman filed a personal injury lawsuit against the man for her injuries, no surprise. At trial, the woman's attorney sought to introduce the following evidence: the witness's statement to the officer, the man's statement to the officer, and the fact that the man was carrying vehicle insurance. The woman's basis for the introduction of the evidence is to prove the man's negligence. Okay, and we're going to get into examples of responses and why they may be wrong. But one thing I can tell you, when you're practicing essays, it's not, you have to have the law down. If you don't have the law down, then it's going to be very difficult, if not impossible, to answer the question. But we have to let the facts be our guide. We have to make sure we understand the question, the call of the question, and so forth. So to begin, the question is, how should the court rule on the objections to the admissibility evidence? Explain. Okay, it's a very precise question. Sometimes you have issue spotters, right? And this one is sort of a issue spotter, but it's a direct question. So we're going to look at an example that might be a problem or will be a problem. In order to prove, this is an example of a writing. In order to prove negligence, the plaintiff must prove duty, breach, causation, and damages. Duty is what a reasonable and prudent person would do under the same or similar circumstances. Breach is when the duty is violated. In order to prove causation, the woman must show that the man's negligence was the cause in fact, and the proximate cause of the woman's injuries. Okay, so if we're looking at this example, we might think, well, negligence is duty, breach, causation, damages. It looks like it's a correct statement of the law, but the problem is we're not addressing the question asked. And this happens so many times. I've seen it so many times. The court the examiners are very specific. They wanted the examinee to address evidentiary issues, because if you look at the issues that were raised, it's regarding the admissibility of the evidence. So here's an example of where the student or the examinee addresses an issue that's not in the case. Will that cost points or credit? Probably not. You know what the problem is that that's going to take you that's going to take the examinee a significant amount of time to write on negligence and talk about, and analyze it, why the truck driver, the man, was negligent. And all of a sudden, you've got 10 or 15 minutes left in your exam to write the real issues. So the problem with this is not necessarily that it was wrong, okay? It's a correct statement of law. It's the fact that you're eating up your time to address the real issues. And that is a significant problem if you spend a lot of time on an issue that's not being asked. You're absolutely not going to have the time to address the big issues and address them in a fashion that will give you a maximum number of points. Okay, so that's one example. We're addressing an issue that's not even being asked. Okay, and like I said, the big problem is it's eating up your time, and you're not going to have enough time to hit the real issues. Okay, and so here is an example, and this may seem particularly obvious, but hearsay is when the man says something about causing the accident and the woman's injuries while he's not in court. The man can't say it unless he's excused from the hearsay rule. Here, the woman wants to say what the man said to show the man is guilty for causing the accident. And this may seem obvious to you, but sometimes an example is best when it's obvious. Okay, here we've got a student or an examinee who's using horrible English, right? Horrible writing skills. And sometimes, even if not horrible, the way a essay response is written can reflect that this person might not be very professional, or this person doesn't have great grammar. And in most essay responses, if you misspell a few words, or you have a run-on sentence, or there's some kind of grammatical error, it's probably not going to cost you. Okay, but like here, where you have just all throughout, it's a terrible grammar, terrible use of sentences, and so forth, that can cost you. Okay, the bar examiner is not going to spend a lot of time trying to figure out what this person was really trying to say. The bar examiner doesn't have 30 minutes to spend on each question. Okay, so if a bar examiner, and sometimes it's about first impressions, right? So if I'm reading an essay response and the person starts out by using terrible grammar or run-on sentences, or 5 out of 10 words are misspelled, then I'm getting a bad impression in my head, right? And we don't want to have a bad impression when the bar examiner starts out reading your response. I mean, bar examiners are human just like you are, okay? And so while you don't want to spend a lot of time making sure every word is spelled correctly and that there's not a single grammatical error, if you can't write a cogent sentence, then that's going to be a problem for you. And so if writing is a problem, it could be for very different reasons. Doesn't mean that you're not smart or that you can't pass the bar exam. It's just you'll realize why it is that maybe you messed something up, even though you technically got the rule correct. Okay, so that's an example. And a tutor or the grading service that BarMax offers, you can do an essay question. Let's say it's an MBE question or a California question or a Georgia question, and you can answer it. And then you look at the model answer and kind of see, what you may have gotten wrong. It's pretty easy to see, wow, I got the law wrong here, or I missed this issue. But what's harder to see is that, hey, you may want to work on your writing skills, even in terms of making cogent sentences, right? Or you might, and that can't really be seen in looking at a model answer. Same thing with other types of problems. So certain problems can only be identified, if you're submitting the question, your answer, to a grader or whatnot, because maybe the grader can point out to you exactly what you might be doing wrong, when you might not see it in a model answer. Of course, we certainly recommend that you practice essays many times, and so you can gain a lot of benefit from a model answer. Here's another example. To fall within the hearsay exception for a present sense impression, the statement must describe or explain an event. Here, the witness's statement is describing the accident to the officer at the scene. Correct. Because she was describing or explaining the event, the statement is accepted from the hearsay rule as a present sense impression. Okay, so the problem with this answer would be that the rule is incorrectly stated. And sometimes when you're, everybody has a different reason, or a lot may have the same reason for why their essay score wasn't as good as they would have hoped or anticipated. Here's an example. Sometimes it's because the law is misstated, and it could be because you don't know the law. The examinee doesn't know the law, and that can be picked up easily. Hey, you might need to work on studying the law more. Or it could be that the person was stressed and just forgot part of the issue or part of the rule. So there could be many reasons, but here what we've got is, in terms of present sense impression, if the only problem, or here the examinee gets the fact that a present sense impression must describe the accident, right? And so, but there's another element that's missing. It has to be at the time or immediately after the event is perceived. So this would-be examinee is not going to do well, because even though it looks like maybe the examinee knew some of the law, the fact is the examinee didn't know all of the rule. And so sometimes, even if you get part of the rule correct, the problem is because you don't complete the rule or you're missing something. And so that's another example of why someone might not do well on a particular question. Okay, so 4, now this looks simple, 3 words, end of answer. And we might wonder, well, is this an example of where somebody might have gone wrong? Well, it is, and that's because of missed issues. If we go back to the fact statement that we have, there were other issues. For example, liability insurance, maybe that was an issue, or maybe excited utterance should have been discussed. And so some answers don't score as well because they've completely missed an issue. Okay, so if this was the end of this person's answer, they're not going to score well on this exam because they've missed issues. All right, so what I'm going to do is talk about what a good response might be. Okay, and so here we've got witnesses' statements. The witnesses' statements to the officer are hearsay. That's correct. Hearsay is an out-of-court statement offered to prove the truth of the matter, sir. We've got the rule statement, issue, rule, analysis, conclusion. You have to use IRAC, and we'll talk to you about that. And when we look at your essay responses, we may indicate, hey, looks like you're freestyling this. We got to follow IRAC. And diagnosing the problems are probably the most important thing you can do on the essay, because you realize what you need to correct. Okay, so we've got our rule statement here, right? Hearsay is inadmissible as evidence at a trial unless an exception to the hearsay rule applies, or the statement is deemed to be non-hearsay by the rules of evidence. These are correct statements of the law. So we've got our rule statements down here. Then we want to get to analysis, right? And when I was a bar examiner and working with other bar examiners for several years, the analysis is critical. There's absolutely no way to pass a question if you don't do an analysis or you skip it. An example might be just regurgitating the facts, right? If you just regurgitate the facts and don't apply the law to it, that's not really doing an analysis. And we can help you figure out what you're doing wrong with analysis. But here, the witness's statements made to the officer were made while the witness was not in court. That's an element of the hearsay rule. And the statements are being offered to prove the truth of the matter asserted. That is, that the man was driving at a high rate of speed when he struck the woman's vehicle. Because the witness's statements were made out of court and are being offered for the truth of the matter asserted, they are hearsay and therefore inadmissible at trial. So if we look at this paragraph, we see that we've got the rule stated, and in this paragraph, we're applying the facts to the rule. And so we've diagnosed this these statements as hearsay. And so we're going to transition Although the witness's statements are hearsay, two exceptions to the hearsay rule are applicable: excited utterance and present sense impression. So this examinee who's making a good response to the question is talking about excited utterance first. Accepted from application of the hearsay rule are statements made that relate to a startling event or condition and made while the declarant was under the stress of excitement that it caused. This is an exact statement of the rule. It's completely correct. So the examinee has the rule correct. Then we get to the analysis. Is the analysis correct? Are they regurgitating facts? Are they only stating the law? Here, the witness made the statements to the officer only minutes after the crash. Because of the short period of time and the fact that the witness had witnessed the car crash, resulting in the significant issues to someone, the witness was likely under the stress of the excitement relating to the crash, a startling event. The witness's statement should be admitted by the court pursuant to the excited utterance exception to the hearsay rule. And this is something else we can help you with, if maybe your answer wasn't, exactly as it should be. Here, the examinee is talking about the facts. You have to put the facts in the analysis, for example, and explaining why under those facts, the rule that was stated applies. And so same thing with present sense impression. In addition to excited utterance, the witness's statements are also admissible pursuant to the present sense impression exception to the hearsay rule. To qualify as a present sense impression, the statement must describe or explain an event or condition made while or immediately after the declarant perceived it. And this is what was wrong with the previous example that we talked about. And that is the examinee left out the fact that it has to be made while or immediately after the declarant perceived it. So we have an accurate statement of the law here. After we've stated the rule correctly, we go into the analysis. Here, the witness described the crash, the event, to the officer immediately after the crash. Because the statements described an event within a few minutes after the event, the statements likely fall within the hearsay exception for present sense impression. So we've got the rule, we've got the facts, we're applying the facts to the rule, so we have the analysis. And then finally, as an overall conclusion, therefore, the court should admit the witness's statements as evidence at trial, right? And so we're coming to a conclusion. We've talked about the rules. We've analyzed the facts, applied the facts to the rule, and we've come out with a decision on how the court should rule. And so we just simply state a conclusion at the very end of it. And so this is simply an example of how problems that someone who may have failed the bar exam can diagnose the particular problems that the examinee had while taking the exam, whether it's spending too much time talking about an issue that's not questioned, whether it's too much time, spent too much time on the law, got the law right, but didn't really apply the facts to the law. All these things can be diagnosed for you, and once you realize what the problems are, you can kind of learn how to correct those problems. So,
hey, I saw a question that came up in chat that is so perfect for what you were just saying that I want to jump it to the head of the line.
Sure.
Luis asks, is there a structure in responding to essays that we can always use? And as a follow-up for what you just shared, maybe you can even use your example to show it. I'm going to throw it back to you.
Sure. All right. Thank you. Okay. There is a structure that you should always use, and that is IRAD. You learned it in law school, all throughout law school, and the same is true on the essay exam or the essay responses. And that is one of the reasons why it's important is because if you have a regular structure that you utilize, you can apply that to your response without having to think about it, right? If I'm going to spend 3 minutes thinking about how I should structure the essay response, then that's 3 minutes. I'm not going to be actually responding to the question. So it's great. If you use IRAC, and you have to use IRAC actually, you'll have that. You'll automatically know, and you can automatically start putting words to the page as soon as you've read the call of the question, the facts. Another reason is, we have to make sure the examiner is understanding what we've said and won't miss anything, right? And so if I don't have a structure, if I'm just doing freestyle stream of consciousness writing, then it's possible the examiner will miss something, right? Or the examiner might think like, you know what, this is a garbled mess. I'm not going to spend 30 minutes looking through this essay and try to find the answer. And those are some of the things that bar examiners really think when they're grading, right? If you can't put a structure together, then when you're an attorney, you're not going to be successful in writing appellate briefs or whatnot. So structure is critical. IRAC is critical. It's what the examiners are used to. They can quickly see that you've identified the correct issues, you've stated the correct law, and that you're actually applying the law facts. So absolutely.
Thank you so much. That is just terrific. I am getting so many good questions. So stick around, Keith, because one of these I'm going to save. You can look at it right now. It's it's near the bottom of the Q&A, and I would love you to answer that one at the end. But sure. I'm going to talk. I have more of my presentation to kind of finish out, but I'm going to take a couple of the Q&A along the way. One, people have been asking. I'm just going to share this screen. People have been asking, hey, well, what's different about MBE with BarMax? Because where I fell short was the MBE section. So I'm going to share, I have more of my presentation about reading your score report, stuff like that. Okay. There have been just some really good questions. This is what BarMax looks like in our website. If you want to see what it looks like in our app, you just go ahead and, this is a phone. This is a phone. Go ahead and download the app for free, okay? BarMax has a free version of the app. Obviously, if you want all the content, you have to buy a program. But one thing we have here is, you can see, like, I'll just briefly show you, in addition to, say, all of these little lecture segments we have 7 segments for each subject, 7 segments broken down. We have multiple choice questions that relate just to that. And then we have a whole other page of multiple choice questions. The important thing about these questions is that they are all real past MBE questions from real bar exams that we have under a license with the National Conference of Bar Examiners, who writes these questions, NCBE. Now, they are stingy about releasing questions. If you had to take the LSAT in this country, you know that they release a couple of full LSAT exams, the LSAC, who makes that test every year. We don't have that luck with the bar exam. They released the last set of new questions that they released. We have down here, it's 30 questions in each subject. It was released as the so-called study aid. That was released around 2018. That's the most recent we have. And it was a long time before that, like several years before that, that they released OPE 3 and 4. That's online practice exam 3 and 4. And these other questions are older. So you're saying, well, you have 265 really old contracts questions. Guess what? They have not changed one iota about the issues and sub-issues that they love to test on contracts questions in the past 30 years. Those questions don't change. There's very little that changes in the law on the bar exam, especially in those common law subjects. They are not testing like the latest and greatest. They are testing whether you can apply this sort of agreed on set of archaic rules and the federal rules of evidence and the federal rules of civil procedure, where there have been, there were some minor updates in 2015. These questions were released after that. So in one way, there aren't a lot of questions. There are about 1,600 altogether, but they're all real past exam questions. Some of them, the format's a little different. They used to write, Albert and Ben, or, whatever. They would give people names. And now they just say a pedestrian, a woman, a manufacturing company, right? So there are little subtle differences, but the issues and sub-issues tested have been the same for decades. And so these questions are super valuable. We also have all of our past webinars and office hours here. And the one I really recommend for how to study for the MBE is the Open Book Bar Exam Study. I'm doing an upcoming one on using essays to learn hard black letter law as well. I think we can get a lot out of using past essays, but this is about making the most of our MBE questions and essays, but mostly the MBE questions I talk about here. The webinars are available in the free version of the app. The office hours are only for BarMax students. So I just hit that to answer a couple of the questions that came up. There were other great questions that we will get to in Q&A. I'm going to throw over. Oh, one other thing. People are asking about in our welcome packet. I'm hoping you're seeing the same screen. I hope you're seeing. In our welcome packet, whoops, sorry, that's just an MBE question. If you go down to your profile, my profile is here, and click this big button, you download welcome packet. Again, this is for paid BarMax students. You'll get all of the essay questions and answers and all of the MPTs and answers. We give you all of the real past bar exam questions. We also give you, we recommend you start with these, but then we recommend that you take the most recent ones and work your way back. This week, NCBE released the July 2021 questions and answers. We don't have those formatted for BarMax yet, to my knowledge. I just asked the person, haven't gotten an answer. But they will be in the welcome packet soon. And in the meantime, you can always click support and ask me for it here. Support will go to customer service. But if they see that it's a content question, they'll bounce it over to me. So wait a day or two, it will get to me. I will respond. Or if you have a content question, it'll be me or another instructor, perhaps Jennifer, another instructor here at BarMax will be answering. So some of the things you get with BarMax are those real questions, a lot of these office hours, and the ability to get support if you need support. And that's, in addition to tutoring. Oh, and this here is where you submit essays. Anyway, I didn't want to spend a heck of a lot of time demoing BarMax, but do download the free version of the app, and then you can see it for yourself. I want to get back into my slideshow. Keith, thank you so much for helping people see some of the things that they can learn from their essays. From a grader, you heard, if you don't have your rule statement correct, your essay is going to go off the rails, or if your writing is off focus, or you give a correct rule statement, but for the wrong issue, you're not going to have time to cover the stuff you need to cover. So there were a lot of good tips there, but turning in your essays for review by BarMax graders is really important. And start doing it now. We have graders working now. If you submit one today, you'll get it back in a day or two to get feedback. And hey, if you have to do that one open book, if you don't remember the law and you have to look at an outline, at this point, you're just trying to get feedback on the format, right? So cheat. Get the rule from the book if you have to. You want to know if you're writing a good essay. This book right here, this is California. The UBE book is about the same size. That's all of the outlines you need for the entire bar exam. Well, all the testimonials that we've been showing, people love our streamlined outlines because they teach you what you need to know for the bar exam, and they are not weighed down with a great deal of fluff. I'm going to get back to playing my thing here because I said I would show another score report. This right here is, again, if their score report shows that they got a 255 overall and a 120 on the MBE, well, they can figure out that they got 135 on the writing. I put this fictional person in Texas. Texas requires a 270 to pass. So again, if you're getting half your points from each side, they just barely made it on the writing, but they did not make it on the MBE. So either they need to do that slow open book study using real questions, or they need to tighten up on memorizing the rules. And if you're doing slow open book study and still not understanding, maybe your score was significantly lower than 255, then you want to think about meeting with a BarMax tutor to get the things explained that you need explained so that you have a good grasp on the law. That's another thing any one of our BarMax tutors can help you with. We tell the people doing BarMax to kind of do things, and we put it in the calendar, but then you take the things in that calendar. The calendar is geared for people who are studying for like 10 weeks or something, the people who are studying full time. But those of you who are starting now, and especially if you're studying part-time, you take that same material and you break it up over more time. The first time through the material, you're learning how it's tested, and your main focus is doing practice questions slowly open book. The second time through, you're still doing practice questions, but now some of that is timed tests. Some of that is those OPE, online practice exams, and timed essays. And you're also going to start working on timed MPTs, or California Performance Test, or Multi-State Performance Test, MPT. They're identical except for, like which fake jurisdiction they're in. But you want to practice that. You want to practice timing. But your second time through the material, there's something I say here called creating memory tools. I have another past office hour I did actually just in June, and I think it was really helpful, I hope, on review and memorization. I talked to all the different, tutors and different memorization strategies that work for different people, because not everybody is a flashcard person, or sometimes flashcards don't help because you still don't understand where the rule fits in the big picture. So having a mind map, or a flow chart or something, or a chart of either a topic within a subject, or in the case of, it's a blowaway office hour that a former tutor of ours did on evidence. You can watch that and see a flow chart of an entire topic. It's incredible. Anyway, these are some of the methods we recommend for creating memory tools. And then the third time through, you are focused mostly on memorization, and you're flipping through, reading, issue spotting, past essays to keep the issues fresh in your memory. So basically you're going through the material 3 times. The memorization phase is that last 2 or 3 weeks. And the other 2 times you go through the material, you're going to put it in your calendar. You're going to space out which subjects you're studying which days in order that you cover everything 3 times. And let's see. I thought I had a different version. I was like, hey, I'm showing the wrong version. This is my old draft. I love it. I'm showing you the draft of my presentation. Here's my real presentation. Where the real final presentation, please stand up. I asked Katie, who has much better skills in this area than I do, to create, a slide to show our current comprehensive course. This is the course that you can retake as many times as you want, but hopefully February of 2021, you will get it done. Once you have BarMax, you have BarMax till you pass at that $24.95 right there. But a lot of people choose to do a bundle, okay, where they buy a course and some tutoring. So they the bundle on the left there has 5 hours of private tutoring. Maybe you just check in with a tutor at the beginning for your schedule, and you check in to see how you're doing every now and then. Or, you save up your content questions and fire away. I had a student who did that. She was super focused and would say, okay, I want to go over these 5 MBE questions and then these 2 essays, boom, 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 boom. She would send me exactly what she wanted to go over, and we would go over it like this. Most people, content scheduling, advice, they need a balance of both. But some people, all content, some people, all scheduling. It's fine. Whatever you need from your tutor, we're experts and we're here to help. Actually, I'm not available as a tutor right now because I'm doing content, but Keith, Jennifer, Melissa, Whitney has some great testimonials that just went up about this recent bar exam. People have loved working with her. She's one of our newer hires, so I'm super pleased with that. Anyway, so those are some of the things we offer there. But like I said, there was such terrific Q&A. Am I still showing my screen? No, I stopped showing my screen. I should show my screen just so something's showing. Okay. All right, there we go. But there was such terrific Q&A. I'm going to look at that now. And I have, how are BarMax multiple choice questions different from BarBreeze? I mentioned it. Ours are real. BarBreeze are written by people at the test prep company, or many of them are. Will the question, okay, so I don't know if the July 2021 exam is in there or not, but you can go ahead and hit support and ask me and I'll send it to you. Okay, Stacy. This is another student who is very frustrated that the bar exam questions seemed different than the ones that they practiced on. Again, you may not have practiced on real questions, depending on whether you were using BarMax or a different program. So practicing on real questions and doing them open books so that you learn to train yourself what they're asking and to eliminate those wrong answers. So many times you can get down to 2 answers, but when you're down to those 2 answers, rather than guessing between, the 2 and saying, okay, I think this one's probably better than that one, that is exactly when you open your outline and you teach yourself, you persuade yourself why the wrong answer is wrong and the right answer is right. Because unless it's one of these questions that's like most likely or strongest or least, I hate those. What is the, plaintiff's worst argument? I hate those. The least worst, those are terrible. They're I don't know. They're not nice. But anyway, unless it's one of those, most MBE questions have 3 clear wrong answers. So if you're stuck between 2, there is a reason one of them is wrong. Go open the rule, figure out that reason, or reread the problem prompt because you may have missed a word. Figure out why that one's wrong. Take all the time you need at the beginning to train your brain to do this. Because once your brain is good at going, there's that word, they're testing that sub rule, then you'll get faster at it. Okay. So that is my suggestion for MBE. And Karina, I would really recommend in terms of scheduling, you're a full-time employee and you plan to start studying in January for the July bar. I think that's terrific. And I would say go watch the Scheduling Your Bar Exam Study webinar for ideas about that. Just take those assignments and pace them out over more time. But Keith, I would love for you to answer, I don't know if you have an answer for this. For international students improving their writing skills, is that something that you want to jump in and talk about?
Sure, I can do that. So, if you're an international student, especially if you went to law school in another country, you may feel like you're at some disadvantage in terms of what was taught to you. and also if there's any kind of language barrier. So here, you have to obviously learn the law and how to write it, the structure for an essay and so forth. But in terms of improving writing skills, my biggest suggestion would be to have somebody look at it. So, if we're looking at the model answer, sometimes we're focused on whether I got the law right or whether I missed an issue. But I would strongly suggest having someone look at your answer, because they can tell you if maybe it was a language barrier issue, or maybe it was some other type of issue, for example, mixing the law up or different things like that. And so in terms of improving your writing, that would be my best suggestion, because something you might not get from a model answer, someone may be able to point it out to you in terms of how to work on your writing skills.
Terrific. Thank you so much, Keith. Getting feedback is super important. And also following that IRAC issue, rule, application, conclusion in a very methodical and robotic way is helpful, because it gives you that structure. You don't want to try to be creative or beautiful on the bar exam. Many civil law countries expect a much more flowery style of writing. I'm thinking particularly if you're from Latin America or parts of Western Europe that are civil law, or even in the Middle East. We've had students from a lot of places, and they have to adjust to that simpler style of writing. But Keith and the other graders were just looking for the points to give you. They
Right.
don't need it to be creative. And in fact, if yours is unique, you're probably in trouble. It's probably not unique for a good reason.
Celeste, if I can follow up on that, is okay. So my degree is in English literature. Okay, that's what my bachelor's degree is. And so when I first started law school doing legal writing and research, I had a real problem, because I wanted to have different transition words, right? Am I using but too many times, or am I using therefore too many times? That's not true on the bar exam. They don't care how flowery it is. What they care, you have to write cogently, right? But what they care about is, are you getting the issue, the rule, and are you doing a proper analysis and reaching a proper conclusion? And so I had a real hard time with that. And it took a lot of work in order to get away from that, because I wanted it to sound great. But, as long as as long as you don't butcher it with grammar and all that type of thing, you can use the same transition word through your entire exam. Because the examiners aren't looking for that. They don't care about that. They want to see if you got IRAC correct.
Yeah. Another good formula thing I got from one of our tutors, and I stole it and teach it to people, is that with application, let's say you have something like that present sense, impression, and hearsay, it has to be something that they perceive, and it has to be, Keith had the rule perfect, but it was at the time of or immediately after the event. And so you take the element, and then you put the word because, and you tie it to a fact in the problem. You use the actual words from the problem. Driver's wife saw, this was, something that she perceived because she said that she looked out the window and saw it, and it was at the same time, because it says in the problem that it was 10 seconds later, right? So you use your element because fact, element because fact. Now there's other transition words you can use. You can put your because at the beginning. You can say when, when, da, da, da. But that way you're making sure that you have an element and a fact in the same sentence, and they're tied. If you have logically tied them with a word like because, or when, or since, then you're doing a good job taking that rule that you've written beautifully up above and really applying every element using facts from the case. I had so many other good questions here in Q&A. Someone asks, do we offer this as a service that someone would review your essays with you? Yes, absolutely. Give us a call. We have tutors that are available to do that. So if you are interested in that, make sure that Katie gets your email or your phone number so that we can set you up with that someone will sit with you and review your essays from one exam. So Jennifer, just hit me up in a message in the support part of BarMax, and I'll go ahead and send you those 2021 questions if you don't have them already answered live. And the hard copy outline, yes. So I am telling California students, if you are taking the California bar, wait until December and get the 2022 versions, because we are having some major updates to BarMax for 2022, and they will come out at the beginning of next month. For UBE students, there are some changes that are happening, so you may want to wait, but I'm telling you they are more minor changes, and very minor changes to a few of the outlines. So you could go ahead and get them, but they do come with the purchase of a comprehensive course. Actually, if you just want to purchase our MBE course, we have a skinnier version of this. That's just the MBE subjects. So yes, you will get a book with your course. And some people are sending requests. Okay. Again, the person who is working full-time, I would recommend watching the Scheduling Your Bar Exam study. For those of you who are retaking, you may be able to save time by not listening to the lectures. Now on BarMax, you can listen to the lectures double time. Arthur Miller, maybe the nation's foremost expert in civil procedure, delivers a wonderful civil procedure lecture, but he is a little bit older and very august and speaks rather slowly. It is fine to listen to it more quickly or to skip the parts that you know. If you say, I don't really need to listen to the contracts formation lecture because I can look at the outline and get the same information while I'm doing questions. So instead of reading the outline or listening to the lecture, I'm going to get the information from the outline, whether this version or the version on screen, because they match, this will match what's on screen. While doing questions, you can skip parts of the lecture. It is not necessary for you to redo things again. You may skip constitutional law and then say, wait a second, where I need a little more shoring up is that bit on federalism and the Dormant Commerce Clause and all that. So you just go and listen to that section. Okay, there's 7 sections and it's chunked up by related topics. So go listen to the one you need. Noah Feldman is fantastic. Again, quite an expert, a Harvard law professor, expert in constitutional law. I think he's a joy to listen to. But if you don't need it, then don't spend your time there. Spend your time on real questions. And I think that's just the best use of your time. For essay review, Florida, Keith, who you just heard from, is also very familiar with the Florida essay or the Florida bar exam. He did teach that exam for one of our competitors. So, and we have him now. So if you want Florida essays reviewed or Georgia, go ahead and purchase a packet of essay reviews with us. Again, essay reviews, our normal price is $50 if you're not a BarMax student, with a package of 10 for $300. You get a lot of value for that $300, but it's cheaper if you are a BarMax student. You get 10 for free with your program, and you get them for $30 each or $200 for a packet of 10. So that's really $20 an essay. And considering that this is attorney time, the instructors who give the comments, it is a great deal. So yes, whether you're submitting UBE essays, California, Florida, Georgia, we have Nevada instructor on staff, and we have, I know Keith is able to possibly handle some other jurisdictions as well. We can do many, not all, but many jurisdictions essays. So somebody asked about Adaptabar. Adaptabar actually uses real questions as well. See, I'm being honest about that, with one big exception. You'll notice we don't have many civil procedure questions in BarMax. Why is that? Well, I mentioned earlier, NCBE is stingy about releasing questions. So our solution is to teach students how to study from past MPE essays. In fact, even if you're taking Florida or California, if you're buying a BarMax program and want me to send you a packet of past MPE essays to use as a hypo, ask in support and I'll send you that packet, because we find that these essays, MPE essays, are written by the same group that writes the MBE. We find that they are a great way to learn and practice the black letter law, even if you don't have to master writing an MPE essay. Okay, so that's the strategy that we choose. The strategy that Adaptabar chooses is to write its own civil procedure questions. And I do hope they've edited them since their first iteration. But I had to tell a student, I can't teach from these. They look nothing like MBE questions. I can't make head or tail of them. Some of the answer choices were a paragraph long. No civil procedure MBE question will have an answer choice that is a paragraph long. So if your questions from a different bar review company look like that, those are fake EJ questions. Okay, they're real questions, but they're not from a real past bar exam, and they were not written by the NCBE. So with Adaptabar, those are mixed in with the good questions. With BarMax, you only get real questions. So there you go. That's the difference. The MBE questions for July 2021 in terms of multiple choice are not released. The NCBE will probably not release them ever. They release questions once in a blue moon, and I'm hoping that they will release some new questions next year, but we don't have any guarantee that they will. Anonymous attendee who graduated law school 15 years ago is totally out of the loop. BarMax is totally for you. I have a student who was using the support feature a lot. Okay, he was not a tutoring student, but was using the support feature maybe a little too much. I had to cut him off some weeks. Like, okay, I'll answer another question from this guy next week. But he was, terrific, worked very hard, had been out of law school. Now I forget how many years, I think 40. He was 75 years old and just passed the bar exam in his jurisdiction. I think it was North Carolina. Okay. He had been out of law practice for 10 years, but he decided to take the bar exam at 75 and passed. And he wrote a fantastic testimonial. You can go read it on Trustpilot. He's just a terrific guy, terrific student. It can be done. Just work very methodically through the materials in the way that I've suggested to my foreign lawyers, to my USJDs, to my young lawyers, to my older, and I'm calling you all lawyers to be, okay? All of you, this method will work because of its flexibility. It works if you've been out of law school for a long time. So there are no MBE questions for July 2021. Do I even using likely? I like that Keith is typing an answer. You want to just jump in and answer that? Should they use the word likely in an essay? I have an opinion.
Yeah. So I was typing an answer and then I lost it and I dug for it and I couldn't find where I started.
So, well, I want to hear it. Should they use likely?
Okay. It depends. That's my answer.
Oh, okay. Gosh.
So
you're out.
Here's the thing. If you have some questions, essay questions or whatnot, will ask you to, you'll have a fact scenario and it could go either way. If you want to say, hey, the court will likely rule, that's great. However, and I can just tell you from experience, I always liked it when somebody came to a conclusion, a real conclusion. And the bar examiners know that the other argument's available. As long as, and you can use likely if you're concerned about it, but as long as your analysis is correct and your conclusion follows logically from your analysis, you're fine. Sometimes, different minds could differ. And so, if you feel better using likely, that's fine. If you just want to come up with a conclusion, that's fine. Just make sure your conclusion logically flows from the analysis and you'll be fine.
Okay. I think that's good advice. That's good advice. So there are times that you will use it, but you do want to come to a hard conclusion after. And if you've applied every element of the rule, if you come to a different conclusion than the one written on the NCBE answer sheet, depending on the type of question, a lot of them aren't clear cut. So if it's not clear cut, you're going to be okay. If someone is a repeater and wants the February 2022 book, we do sell it to current BarMax students. So this is applying to Fritz, a current BarMax student who wants to get the 2022 book. You can purchase that for it's a pretty low price for our printing and logistics and whatnot. We don't sell the book separately from the course if you're not in the course already, if that makes sense. So you can buy one book for February 2022. I think it's $100. So reach out, get some help with that. And yes, you can buy the book. Okay, so Peggy offers under rule here, analysis, therefore conclusion. I think you have given me a structure for IRAC right there. Peggy, I think that is a structure for IRAC. You just have a little heading at the top that says, what your issue is. It doesn't have to be a whole issue statement. It just has to identify it, personal jurisdiction over, airplane manufacturer. Okay. Corinna, you had a specific question, and I would say reach out to us, and because I don't know the answer to that one, so just reach out and we'll figure it out. Okay. Louisiana is a civil law state. Oh, I am so sorry. Peggy, our bar exam, yeah, we don't have a course for you. Keith may know more about it. He's trying to type something, but I would say write to us separately for that because we're not going to have a lot of Louisiana people here. Jennifer Cavart. Oh, yeah. What were you going to say?
I was just going to say, Celeste, Louisiana is like a different country.
I know.
But
Louisiana and Puerto Rico. Louisiana and Puerto Rico are in, our country, but they have a completely different legal system.
That's right. But, a lot of what we teach is applicable to any bar exam. So, in terms of Louisiana law, in terms of materials, we can try to help you find something but in terms of how to structure an essay, how to answer multiple choice questions, certainly, I think you could benefit.
Okay. I appreciate the kind comments from Clay Hummer. And I just want to tell you that we wish you all the best success in your recovery. Clay is, fighting cancer and studying for the bar. He didn't make it this time, but he is sticking with it because he's had a lot going on. So he might be in that category of wasn't able to focus quite enough time on studying. Hopefully you will be doing better this time, Clay, but we're really, thank you for sharing your kind comments. So we have people who are getting caught up. All right, so I think that's it for the main Q&A. There seems to be an awful lot going on in chat that I missed. Hopefully you're getting your questions answered there. Just let me see back. My presentation is showing, right? Keith, is my presentation showing? Yeah. I don't know.
Yes, it is.
Yeah, it is. Okay, good. I never got to this part of my presentation, but that's okay. We'll do it now if this is helpful to you. Some of you have this on your bar exam report as well, your score report, and some people have trouble understanding this. It's going to look like that in one state. It looks like that in another state, like that in another state. So let me take this student here. Actually, I think I know which student this is, and I can talk about her a little. Oh, no, that's a different one. Yeah, that's a different one. So the one I'm thinking of is this one here. So this was her 6th attempt at the bar exam. Okay. And you can see that her MBE scaled score was 131.4. And that nationally, 45.8% of the country scored lower than she did. Okay, that means, 40 whatever or 50 whatever percent scored higher than she did. So if you look at, for example, civil procedure, she kind of kicked butt on civil procedure on this particular bar exam administration. She was taking a different bar course and hired me to help her with civil procedure, constitutional law, secured transactions, and real property. We worked intensively on those subjects, working from past MPRE essays. By the way, I love secure transactions. It's like my jam. Those essays are so easy to game. They ask the same. They're like, telenovelas, Latin American soap operas. They follow the same plot line every time, right? And they're still awesome. Okay, not all telenovelas follow the same plot line, but you have to admit there's some commonalities. Anyway, the secure transactions questions are like that, very predictable. So you can see that she did really well on civil procedure. She was, in the top 40% of the country on civil procedure, constitutional law, and certainly within the top half of the country on real property. She scored, in the bottom quarter on contracts, which was disappointing to her. So in this administration of the exam, she was a couple points short of where she needed to be to pass for her jurisdiction. In February of 2021, on her 7th attempt at the bar exam, she surpassed the cutoff point for her jurisdiction by 14 points. After 6 tries of not making it, she blew it out of the water. She was 14 points over where she needed to be. And I want to tell you about this woman. The whole time I worked with her, I thought she is going to be a terrific attorney. She, because, I worked with her for this exam where she improved in the areas where we worked hard. She got a 5 on a secured transactions essay on this exam. She was very methodical. She was very tenacious. She had perseverance. She was diligent. I thought, man, those are the qualities of a great lawyer. This is a woman who's going to be a great lawyer, probably is a great lawyer right now because she got sworn in earlier this year. But this was her 6th attempt at the bar exam, and she passed on number 7. Now, hopefully, if you have failed once, you're going to pass on number 2. But I want you to know it doesn't talk about your value as a lawyer. Certainly doesn't talk about your value as a human being. Okay, if you didn't pass, but not even your value as a lawyer. This woman is going to be a terrific lawyer. So I threw that story in there, but it also helps you understand that, hey, here's someone else was struggling in real property, but scored in the top half of the country in contracts. Okay, so, I would not. Now, how should you use this information? Does that mean that this person doesn't need to study civil procedure and contracts? No, that's really dangerous because this stuff just doesn't stay in your head. You do have to study it again, but understand that maybe evidence is an area where you weren't really understanding what was going on. And you'll need to work through a lot of hypos and maybe with a tutor, if your evidence score is looking like this or lower, right? So that's where you can say, all right, I still need to work in all the areas because they're going to ask me about all 7 again next time. I need to be prepared for all of them. But this might show me where I need to bolster my understanding, where I wasn't understanding what was going on. And I might need to put just a little more effort. But do not blow off the other areas or your scores could be in danger of seesawing. Okay. And so that was the other thing I wanted to cover in terms of real practicals. We do have more webinars coming up. We have one that doesn't pertain to the bar exam. It's a different exam. But then we also have one more bar exam related webinar And it would be really smart if I had the date of that in front of me, but it's in December, I think. Anyway, keep your eyes on your emails because that's where we generally announce these things. And keep in touch, okay? Let me know, how your studying's progressing. You can reach out in chat. In the support link of BarMax, okay? We're here for you. Me, the other instructors, we want to help you. If you can get tutoring, then please do. Someone wanted to see the books, which is why I took off my fake background. Because my fake background's white, my hands are white, my wall is white, well, it's gray, so things didn't show. But this is the book. This is the California book. I have the UBE book. Oh, we also send this MBE. So you'll get books, but your whole outline, the outline is just this. This book is a bunch of MBE questions, those online practice exams. They're called online practice exams because they were released online, but your exam will be on paper. So you should go ahead and practice on paper. There's a little bubble sheet in here and everything. So you can practice. When you do the actual practice test, you can do it just like you'll take it on the actual exam. So Keith, we got a few more Q&A. Some of these we already answered. Do you have anything you want to add for these folks who are still hanging around? We still have 63 people here who find it valuable to talk to us. Keith, got anything else?
Well, I've got a lot of stuff. It's just so we can't get it through.
We can't get it all. That's true. You showed me all the stuff you wanted to talk about today. I was like, how about we keep it to essays for now?
Yeah, that's right. So the one thing I would mention, and you've already mentioned it, Celeste, is that when you're studying or when you're doing practice questions, you're going to study the materials, right? You're going to study the law. But when you're doing practice questions, for example, the MBE, don't just see if you got the right answer. That's not going to help you. Okay. I learn more from my failures than I do my successes. So if I get a question wrong, I'm always happy about it because I won't miss it on the bar exam because I got it wrong and I figured out what the answer was. So
what a great attitude. You're like, aha, here's something for me to learn. Points to gain. Here's a point I can gain next time.
Yeah, don't just see if you've got the right answer. Look at the wrong answer, even if you did. Let's say you got the answer right. Look at the wrong answers and why they were wrong. Right.
Absolutely.
So there's a lot you can learn from an MBE question. Don't just read the question and see if you got it right. That would be my last kind of comment there for people who are studying.
Okay, so someone asked a great question that I want to answer now. So I'm going to start sharing my screen again. Is it going to let me do this? Hang on. So I want to share desktop one, share. Can you see my screen, Keith? You should be able to see my BarMax.
Yep, I can see it.
Good. So someone asked, is the MBE all common law? No, but let me walk through because the sources of law, especially for my foreign students, but even for my US students, civil procedure is just helpful to know, right? Civil procedure tests the federal rules of civil procedure. So this is what goes on in a federal court. There's a constitutional issue that comes up in here, which because federal court jurisdiction is set by the US Constitution. So the jurisdictional issues are tested somewhat in con law and somewhat in federal civil procedure. And one statutory thing about jurisdiction as well, that's where we get that statute about the amount in controversy, all that, that's statutory. Little couple other statutory things, federal statutes, Class Action Fairness Act. It's in there. It's another way to get into federal court. But basically, it's mostly the federal rules of civil procedure. So that's statutory for the most part with a smidge of constitution. Crimes, criminal law is going to test mostly the common law of crimes. I'm going to show you the 7 topics here. The first 4 topics, elements, accomplice liability, crimes against person, crimes against property, and defenses. Oh yeah, defenses. We got to cover our self-defense and things like that. A few other defenses in there. those 5 segments are testing mostly common law, but there are times they want you to know the more modern statutory rule, like the model penal code rule. Also, when we get to homicide, okay, there's no such thing as first or second degree murder under the common law. The common law, murder is murder. Okay, so if you have degrees of murder, you're talking about a statute. Where they want you to know a statute on the criminal law questions on the MBE, they usually provide the statute. They say, in this jurisdiction, second degree murder is defined as blah, 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 or first degree murder is defined as, or they'll say, this jurisdiction defines assault as. So then you just need to apply exactly the rule that they give you, even if it's some weirdo rule you've never seen anywhere. The last 2 sections are criminal procedure, and that comes from the US Constitution. Okay, constitutional law, we have the course on constitutional law, but let's face it, it bleeds into every course. Well, maybe not every course, but it does bleed into criminal law. Right here, it does bleed a little bit into procedure. It does bleed into property when we're talking about takings, right? So there are kind of overlaps. And here, the 4th, 5th, and 6th Amendments and other criminal procedure, this is about the rights of criminal defendants, surrounding searches, seizures, their arrests, their trial, juries, all of that is covered here in the criminal procedure portion of the course that we call crimes. Okay, so getting back to our subjects. So this is primarily common law. Contracts, primarily common law, but there is one large statute you need to know. Uniform Commercial Code is a big old sprawling statute that has been adopted by, in part by, various parts of it have been adopted by all the different states. And UCC Article 2 governs contracts for the sale of goods. So you have to look at every contract you're reading about and figure out, is this for a sale of goods or something else? So then you're either applying the common law or you're applying the UCC. There are plenty of areas where they're the same, but what does the bar exam like to test? The areas where they're different. So that's what we teach. So you'll learn those in the BarMax course. That's what's taught there. Constitutional law is based on the US Constitution and all of the, couple centuries of case law that we have now, interpreting that and helping us apply it in our lives. Evidence is based on the federal rules of evidence. This is straight up statutory. Okay. If you are a foreign lawyer, this is the weirdest thing about our court system, is what we do and don't allow to be admitted in federal court. And that's what you'll learn there. Real property is based largely on the common law. So if you had to learn the common law of property to practice law in Australia or Canada or, the UK or any other common law jurisdiction, I know that you guys also learn this stuff in Ghana. I mean, there's plenty of law schools that teach real property and it will look awfully familiar to you. The one exception being what I referenced, the takings clause of the US Constitution. We mention it in common law and we also teach it here. Because that can be tested on the bar exam. Torts is primarily common law, but some of it has been changed by statutes in various jurisdictions. So we kind of tell you what the majority rule is and where the bar exam might want you to know that there are other rules out there. We teach both. Okay, so that's it. Those are the MBE questions. Remedies takes the common law remedies, especially the equitable remedies, and tells you kind of how they apply in torts, in property, and in contracts. So it's kind of a course that sort of reviews the question of what can I get out of a court for this harm, and for all the courses. There is no actual remedies section on the bar exam, but remedies issues will come up in lots of questions. So that's it. I answered that one kind of at length, but it is a useful question, I think, especially for foreign lawyers. And then another really useful question is MPT. How can I incorporate it? Yeah, you have to put it in your calendar to practice it. And you guys have all done an MPT, so you know what it looks like. You get this big file and this library. And if you were going to practice one, it would take 90 minutes plus all the time to review if you were going to practice a timed one. And so that is really a significant commitment of time. But if you can figure out what skills you need help with, do you need help just practice just reading that file and organizing your outline? Read the file, identify the issues, organize your outline. Well, there's nothing wrong with just spending 45, 50 minutes doing that for one past MPT, or maybe an hour while you're still working on this skill. Spend an hour doing that, and then go read the samples. We have, in addition to the NCBE point sheets, we have samples for all the exams from 2013 to the present. We have samples from New York, sometimes Minnesota. These were successful examinees. And you can see, how did some other person structure this? How, what issues did they identify? So you can look at the NCBE point sheet, but I find that for the MPTs, it's actually really helpful to review what other successful examinees did. And maybe they type 8,000 words a minute or something. You don't have to worry about so much writing everything that the top New York answer writes, 10,000 people. You don't need to be the top of 10,000 people, right? You need to be the top 50% of your state, So don't worry about being the top 2 people, but do look at it as exemplary of the structure of the issues that you should have hit, because you can start practicing that skill. You can practice that skill with a tutor, or you can practice it on your own, but practice that, review, outline skill, and then do some where you also practice the writing skill and turn those in for review. And while we're here looking at BarMax, I want to note that of these past office hours and essay and webinars, again, webinars are free to everyone, but office hours are for BarMax students only. All of these discussed the MPT or California Performance Test. Okay, all of these. Actually, there's one more that focused on California specifically, although they're really the same. So you can watch the office hours, but that's a lot of time. Don't watch them in your best study time. Watch them, when your brain is a little otherwise, maybe when you're making dinner or something like that, right? That's when to watch office hours. But during your focused blocks of study time, focus on doing past MPTs. So that was a good question that Robin asked. Chiluba. Oh, this is good. Between the MBE and MEE, which ones should we focus more on? Well, your grade will be half writing and half multiple choice. Now, by going through multiple choice essays, you'll hit a lot of doctrine, but believe it or not, by going through past MEE essays, you'll hit a lot of doctrine as well. And remember, the rest of the subjects are tested only in essays. So if you focus too much of your time on the MBE, then you will not study enough secured transactions, agency and partnerships, corporations, trusts, wills, family law, and conflict of laws. The July bar exam had a corporations, conflicts of law, what do they call it? Crossover question. In other words, it was a corporations question that also had a conflict of laws issue. It also had a family law question and a wills question. So someone who spent all their time studying for the MBE may have done very poorly on the essays this last time around. It was very MEE subject heavy. Okay. And that was tough. I thought that, I thought a couple of questions were pretty, and some of them were forward. But yeah, so I would say make sure that you're devoting time, Chiluba, to doing both. That when you're doing your MBE topics, Sometimes I would tell students to do an essay sandwich, to take those 3 hours and spend the first hour going through a couple of MBE questions slowly, open book, and then use the second hour to work on and review an essay. And then use the third hour, or when you're done with the essay, use the remaining time in your block to do MBE. And that way you'll make sure that you're doing it when you're first going through. If you're doing multiple choice, do towards essays, and then do more towards multiple choice, because then all of this will help you learn the doctrine. Reviewing lots of past essays helps you see the doctrine in action in a deeper way. Even like the evidence essay that Keith showed us earlier. So anyway, these are such great questions. I think that's it here. We have a ton going on in chat, but it looks like people are getting their questions answered. And with that, stick around, with BarMax, not here because we're going to get going soon, but you'll find that we have a lot that we're very invested in helping you to pass the bar exam. I take it very personally, when my students succeed. I mean, you've heard me talk about a couple of them. Malcolm, who was 75 years old. Oops, I said his name when he passed. And my other friend there who passed on her 7th try. I really care about my students, and I'll stick with you. So get involved. And no matter what you do, I hope that this session has helped you to think about how you can make some changes going forward, okay? Make some changes and do what you need to do for next time. And I hope that by this point, if I had my little thing up, I would put the emotions chart again. And I hope that you're feeling hopeful and determined and focused on getting where you need to be in February. Okay, good luck, all of you. Thanks for being here today. Bye-bye.